Let's start with number 88 and 89. Counselor?
Yes, Your Honor. Phil Rothschild from Hiscock Legal Aid.
You want any rebuttal time?
I'd like to reserve 2 minutes, Your Honor.
How much, Ken?
2 minutes.
Two, sure, go ahead.
In Rudolph, this court found that the trial court should exercise discretion in determining YO eligibility. We feel that it should extend to have the court make a particularized finding of facts or factors under CPL.
Tell us what's the issue in your case? What happened?
Well, in my case, there essentially was an implicit finding of eligibility, and I think that the court never said he was not eligible and seemed to believe that he was eligible, and also the appellate division, the Fourth Department, also seemed to believe that he was eligible.
But was he an eligible youth as defined in the statute?
Yes, he was, Your Honor, because we would submit it's fairly clear that he was eligible insofar as under 72010 subdivision 3, defense counsel asked for YO, set forth mitigating factors contrary to respondent's claim. She set forth, look, this is a constructive possession. There's absolutely no proof outside of the statute, outside of the statutory presumption, and there's no witnesses, no one to say that they saw him with the gun, use the gun.
But under the statute, it says an eligible youth is someone of a certain age range, except, and one of the exceptions is an armed felony, right?
Yes, Your Honor. However, appellate divisions also can make their own finding of eligibility, and they have done so regularly on Mere W., Crookshank, which I believe went to this court under People Maria C., and that can be done. And in this case, we essentially have an implicit finding, and what the respondent's position is, well, that doesn't matter because the judge didn't write out, hey,
well, where do you draw the line? Because obviously there's mandatory YOs, and as Judge Stein is saying, this one you're not. You are not YO eligible unless. And I know you and your co-counsel are going to argue we should extend Rudolph to say we ought to pursue the unless part as part of Rudolph.
I think this case is actually, my client is actually the poster child for why the rule should be extended, because essentially you have both the trial court and the appellate division implicitly finding him eligible.
I didn't get that from Judge Walsh.
Well, Judge Walsh basically said, I'm going to die because you took your case to trial. He said that 3 times. He said it over and over and over again. But as far as the finding of eligibility, when defense counsel said, look, there's minor involvement, there's no witnesses, all you have is the gun at the feet, no indication he held it or possessed it or used it.
Counsel, isn't the statute, just reading the text of the statute, isn't the presumption every youth is eligible unless, so you start out with the eligibility, and you're working against the presumption of eligibility?
Yes, Your Honor.
As an eligible youth?
Yes, Your Honor. However, as I said, the court does have discretion in making that determination of eligibility, and that discretion.
Yes, but I'm saying you start out with the presumption.
Yes.
And you're looking to check these factors to see if they
Yeah.
are carved out by the legislature.
Indeed, Your Honor.
Doesn't that also then require that you're always making a finding of eligibility? It's a threshold question?
It's a threshold.
How do you know who's eligible if you don't look at these factors?
Well, that's just it. And how do you know? And how does an appellate court know unless, in fact, it's put forth on the record? And that's the problem.
What's the judge's responsibility in this area?
I think that the judge should make particularized findings of fact and should set it forth for the appellate court.
Affirmatively?
I believe so, Your Honor, because
Suppose you're 30 years old and you commit an armed felony. Do you have to make a finding that they're not YO eligible?
Well, by statute, they could never, ever be.
And there's a statute here that says you're not eligible if you committed an armed felony. And now you want to say, but, there's another section, and you, the court, not me, the defense lawyer. I'm just a lamppost here. I stand next to my defendant, and I do nothing. The court does it. And if the court doesn't do my job, then we're going to reverse it. I mean, I'm wondering where the line gets drawn.
Well, I think in my case, the line is drawn basically at the relief that the people are requesting, saying, hey, even though there's this implicit finding, because the judge didn't check off this box, this person, and he's not eligible, and don't bother with appellate review.
Where's the implicit? I'm missing the implicit.
Well, basically, as I said, the appellate division, first of all, the court didn't say you're not eligible. The appellate division didn't say, as they said in Middlebrooks, you're not eligible. They just said it's not an abuse of discretion.
Doesn't the statute say you're not eligible?
Well, the statute says you're not eligible, but you can be eligible. And as I said, appellate divisions can and often do find eligibility even though the trial court does not. And we would say that essentially that's what occurred in this case.
You started to answer a question about what
the judge has to consider and put on the record, and I'm curious as to what you think that litany should be, because we have in another case, the judge just saying, I'm not going to do it. So what is the judge's, if the judge does consider YO, what are you saying the judge has to say?
Well, there are two aspects. First of all, the eligibility under 720 10 subdivision 3, whether in fact it factors in circumstances of the crime. But more importantly, what the appellate division decided in this case, that this was not an abuse of discretion, we would submit that that was wrong, essentially wrong, because there clearly was an abuse of discretion as a matter of law. First of all, the denial of the adjournment. In this case, the court does have discretion in determining its calendar, but that's not unlimited discretion.
Why did the judge do what they did in this case? What was the motivation?
The denial of the adjournment?
Yeah,
I think it's pretty clear. It was the judge said over and over again, you took your case to trial. I'm not going to give you.
So your basic view is that the judge was just annoyed that they didn't take a plea and therefore wasn't going to consider the YO, that there was a recognition that it could be considered?
I think it was fairly clear. I mean, I don't know if it's my view, but that's what the court said over and over again.
Can I just ask, do you think Judge Walsh made a determination on his YO status? I mean, the PSR said that they recommended YO for him, right? On Lowe, we're talking.
Yes.
And the way I read the record, it's unclear to me whether Judge Walsh, actually made a determination on his YO status. What's your position on that?
I think that the judge essentially couldn't make a proper determination.
So the answer is no, he didn't make a determination. And do you think it was requested?
Oh, it was definitely requested by trial counsel over and over again, as well as the adjournment.
Well, as I read the record, counsel came in and said that they called Chambers and requested an adjournment and was told that the sentencing had been moved up.
Yes.
But there wasn't a real clear further request on the record, I don't think, for an adjournment. Counsel talked about how they needed this information and how important it was, but didn't say, never really asked the judge. And it's not clear whether the judge was even aware of the first request.
I think if you look at page 603 to 605 of the transfer, I think it's pretty clear that defense counsel said, look, there's much information, we really need to get this. I think it's pretty clear that she requested another adjournment and the court just said no.
Is there anything in the record that indicates why she couldn't have presented that information without this report?
Well, what she indicated on the record was, look, the Center for Community Alternatives, which, by the way, in the Amir case was used by the Fourth Department to overrule the trial court's earlier denial, basically said they can get information that I can't. These are people, this is their job, this is what they do. And I don't believe the court ever said, look, we don't have enough time and this thing is, there's too much, there's too much delay. It was never claimed by the trial court. And we would submit that it was an absolute abuse of discretion, which led to a failure to exercise discretion.
Let's hear from your adversary, and then you'll have your rebuttal.
James Maxwell for the people. May it please the Court.
Counselor, your adversary seems to indicate that the judge appeared to be motivated by being annoyed that the defendant did not take the plea. Do you think that precluded, in essence, precluded YO consideration by the judge, that that's what happened here?
Well, I think I have to step back from that just one step. What precluded YO consideration is that adjudicating him a youthful offender in this case would have been illegal.
Yeah, but he's intimating there's more than that.
Well, having said that it would have been illegal, I don't think Judge Walsh analyzed it that way. I think he analyzed it as, here's a young man who was given a reasonable offer before trial, had the poor judgment to go to trial, lie to the jury, and get convicted, and the judge now has heard all the evidence at trial, and he's going to go ahead and sentence him.
Why is it illegal?
It's illegal because the judge never made findings that either of the exceptions under the statute fit to make him an eligible youth. So I'd have three suggestions for the Court as you try and give guidance to the trial bench. One is that an adjudication of an armed felon as a youthful offender is illegal until and unless the judge makes a finding that it fits one of those categories.
Well, how about unless somebody asks? I was picking on Mr. Rothschild about the fact that everybody seems to say it's all on the judge.
Yes.
Motion or, something.
That's number 2.
Well, no, let me stay on number 1.
Okay.
I'm just reading the statute as the plain text, 720.10, Section 1, defines a youth. Section 720.10.2, eligible youth means a youth who is eligible to be found a youthful offender. Every youth is so eligible unless. And you've got to work through this to figure out if they're an eligible youth.
Yes.
It looks to me like the presumption works exactly the opposite of what you've suggested. How am I misreading the text?
I think it's fair to read that text as that the person is not eligible unless one of those two things exists.
Every youth is so eligible unless. Not they're not eligible unless.
I think just using unless shows that you have to make that finding.
Counsel, why isn't this a logical place to go based on our precedent in Rudolph?
Oh, I think
the whole purpose is if these kids are eligible in some sense, the judge ought to just take a look. What's wrong with, in this particular case, where they obviously wanted them to take a look, what's wrong with that? Why isn't it consistent from a policy perspective in what we were trying to say in the Rudolph case?
I think consistent with policy and consistent with Rudolph, because Rudolph was one of those cases where you read the statute and you apply it. I think, again, here, you read the statute and you apply it, God bless you, and you come to the conclusion that the legislature structured this in such a way that an armed felon does not get youthful offender unless.
If you go to that unless, Mr. Rothschild touched on this too, I don't understand why the judge couldn't wait for the CCA report, and I don't understand why the court gets to move it forward to 2 weeks when everybody else, I assume he was incarcerated during this time. It wasn't like he was. So why wouldn't we wait and see what the CCA report said, and maybe those are the facts that would lead to possibly an exception under the.
Because what the defense attorney was arguing is I need the CCA report for history and background. And history and background doesn't get you to mitigating circumstances that bear directly on the case.
Because the judge said, well, I'll put it in the file. And she's, no, I don't want it in the file. I want it as part of the sentencing record.
Right.
And that at least implied to me that it was going to be an important factor in determining what the sentence would be, which could lead to Mr. Rothschild's implicit for.
Well, it may have to do with the ultimate sentence that then the appellate division cut in half, but in terms of whether the person is an eligible youth, the defense attorney's arguments weren't geared towards what would make that person an eligible youth. They were geared towards history and background.
Yeah, but the CCA report would obviously speak to whether or not the guy would be eligible. Now, there's two factors, you know. That's kind of straightforward. It's funny, Mr. Maxwell, only speaking as Judge Fahey, it seems to me that this moves towards an abuse of discretion. The question is whether or not it's harmless. I think that's really on this particular issue.
Well, and in that equation, I don't dispute what you're saying, but in that equation is the fact that the appellate division has already cut the sentence in half. So we got that.
Right. But it's not a mood issue because he'd be, what is it, one a third to four on an E felony. So it's far from mood in this case.
Right.
So.
But in the big picture, I suggest that you should rule that the defense should make the showing before the judge even has to make the finding.
What I'm wondering here is maybe this isn't teed up for a big picture decision. So maybe it's a small picture decision.
Lowe itself is probably small picture, yes.
Go ahead, Judge Rivera.
I just want to clarify because I'm really not understanding your argument. What then is the way, depending on this argument about the way you're reading 720.10, 1 and 2, how are you then reading 3? How do you harmonize 1, 2, and 3?
3 is a way to take what a person would be presumed to be ineligible, and in certain circumstances, not all circumstances, but in certain circumstances, allow a judge to make a finding that they are eligible. And so I think that should be the statutory interpretation, and the approach the court should take is that until and unless the defense makes that showing and the court makes that finding, the judge doesn't have to deal with it.
The judge doesn't want to hear about it.
Well, the judge wasn't asked to hear about it. He wasn't told, this.
Well, basically, they were.
He was not about to give him YO.
But counsel,
I get.
That's, I think, clear to everybody.
But he didn't really consider whether to give him YO, even though it's obvious they wanted him to consider.
And it's kind of a charade to go ahead and say, well, you have to go through this process when the defense hasn't even made that showing.
No, counsel. Let's get to number 3, and we'll get back to this point you're making. It's a charade. Number 3 says, notwithstanding the provisions of subdivision 2, a youth who fits under these exceptions can still be eligible if the court determines. It doesn't say there if upon motion by the defendant, if the defendant so requests. If the court determines. Why can't we read that as the court has to make that determination as part of the definitional sections here of what is who is an eligible youth?
Well, I'm just suggesting, Your Honor, that the legislature went out of its way to put that in a separate paragraph to say that the court can change what is otherwise ineligible to eligible, but only under certain circumstances.
Right, but that's about the discretion of the court. It's not about whether or not the court has to actually exercise the choice of figuring out whether or not a particular youth who is otherwise eligible, except they fit these 2 exceptions, then can be accepted from the exemption under number 3.
All I'm suggesting is the discretion comes in only after you've taken that step. The discretionary step is whether the defendant.
Oh, I'm not in disagreement with you that 3 is solely within the court's discretion. The question is whether or not making the determination is discretionary. It seems to me you're arguing that both steps are discretionary, and I'm not clear as to your argument why the language of 720.10, given 1, 2, 3, and the purpose as we've described it of the statute, and Rudolph suggests that the legislature is interested in trying to give this kind of status to youth.
Well, again, maybe I'm not going to be on the same page with you, but it seems to me that the first step is more legalistic. The second, and then that only after you get over that hurdle do you reach the discretionary part.
Okay, counsel, one more question. Add this on.
Yeah, I was just going to, when you said that it's the defense responsibility to bring this to the attention of the court, so when is that supposed to happen? Is this before the sentencing or at the time that you ask for YO? Or I'm just unclear when you think this is, the defense is going to be ready to make that showing.
Well, I think that's showing. Let's use this case as an example. The defense attorney at sentencing says, I'm asking for youthful offender, but she doesn't go any further to say, and this is why the person's eligible, this is why, even though it's an armed felony, they should get it. And I'm suggesting that there should be a burden on the defense to persuade the judge in that circumstance so
it should be a part of the request for YO, and so you're making the request for YO, and you know that your client has a felony conviction, so you're saying automatically the defense counsel has to rely on 3 and say this is the reason that my client would benefit from the exception.
Yes. And it would fit the exception, I guess, would be the way I put it.
Or would fit the exception.
Yes. And then from there argue that within the court's discretion that it should be a youthful offender.
Okay, counsel.
Thanks,
Counselor. Rebuttal, counsel.
Yes, Your Honor. I believe the Respondent's position would put even more barriers towards the exercise of the court's discretion and appellate review of that discretion, saying, well, you have to make a motion in order for the mitigating circumstances to be considered. I don't believe that's in the statute.
I wasn't suggesting a motion. What I was thinking is that when you're negotiating all these pleas and, you know, not everything goes to trial and not everything, you know, is confronted in black and white, and the defense lawyer comes in and says, Judge, we've reached an agreement, DA agrees, it's 3.5 to 7, and he's a good kid, and you should give him the minimum. Does the court then say, well, wait a minute, before you guys all hug and say this is a great deal, I'm going to make a YO determination? Is that the obligation of the judge to interfere with the plea bargaining process under those situations?
I don't know if it necessarily interferes with the plea bargaining process under this Court's ruling in Rudolph. This is something that this Court said. It can't be bargained away.
But armed felon is what I'm saying. I mean, he's not eligible. But you want to suggest that even though he's not eligible, and we have now agreed to a reduced sentence and a reduced plea, the judge is supposed to say, all right, I know he's not eligible. I know you guys have gotten an agreement that everybody's satisfied with, but now I've got to do something extra, and I've got to make a determination as to whether he's YO eligible or not, and I think he's YO eligible. The DA then says there's no deal. We're going to trial.
Well, then that is what it is. But as far as the Court's responsibility, I believe that the idea is that this decision should be made by a judge. It should be made by a trial court, and it should be able to be reviewed. And as far as the barriers suggested by opposing counsel, I would submit that they are contrary to public policy and contrary to Rudolph.
I think Mr. Maxwell's asking for too much when saying you've got to specifically say why. I think if you say Y.O., the bells go off, and you take and say, why do you think that, he's entitled to the override?
And additionally, in this case, basically, she did set forth mitigating circumstances. Judge Fahey, regarding your question regarding mootness or harmlessness, this was not harmless because, first of all, the purpose of 39040 is to allow the defendant to have input. It makes it less constitutionally suspect. Secondly, regarding the mootness, again, 5 years versus 4 years. Additionally, it takes the purpose of the Y.O.s to make sure that the defendant doesn't have the onus of a criminal record. So this goes just beyond.
Do you want this remitted to Judge Walsh for resentencing?
Well, Judge Walsh, I believe, is retired.
I see. That's why you're so striking your argument.
Okay, thanks. Okay, counsel.
Good afternoon. Barbara Davies for Mr. Middlebrooks.
You want rebuttal time, counsel?
1 minute, please.
1 minute. Go ahead.
After Rudolph, my case presents the question of the court's role. I believe, Your Honor, mentioned that. What should the court do in this situation?
Tell us, what should the court do?
Well, and in our case, the court did nothing. Defense counsel did nothing. The court did nothing. Everybody knew that Mr. Middlebrooks was 18 years old.
Should there be a distinction? In one case, the request was made, and certainly the court was alerted to the fact that perhaps the defense thought that there was some basis for finding doing Y.O., whereas in your case, nothing. Nothing. And by the statute, your client's not eligible.
He's not eligible, but we would ask the court to read the statute as a whole, and bearing in mind the policy considerations that the court thought were so important in Rudolph, a fresh start. And what we're asking of the –
But the statute says that the court has to do enumerated things when the court is dealing with an eligible youth, and it defines an eligible youth. Someone who commits an armed felony is not under that statute, at least how I interpret it, an eligible youth. So why should there be any requirement on the part of the court to initiate a discussion when the defendant, him or herself, doesn't raise the issue?
Well, we believe that there will be a gap in the statute unless there is this review, and we are cognizant of what Judge Rivera said in her reading of the statute, and we would ask that the sentencing court merely alert defense counsel. We're not asking that the sentencing court run the hearing or do anything other than just alert defense counsel who has said nothing about his client's status.
Well, what does the court know? I mean, that you think that they're on notice and the defense isn't. You got a guy who killed 3 people, all right, and now there's a plea coming in front of the court. Does the court say, by the way, your client may be why you're eligible? Do you want to bring that up?
Yes, we would want the court to do that. That's exactly what happened in this case.
Where's defense counsel?
Well, unfortunately, defense counsel, you could make the argument defense counsel was ineffective in cases like this, where you have an armed felon who might be eligible for youthful offender, and defense counsel says nothing, and perhaps he's ineffective. But should the client suffer because his counsel is not proactive enough? And that's why we would urge that the court simply engage in this limited logical extension.
How many people do you think that would be back in front of us on a 440 if we found your way? I'm just curious. I have no idea how many.
On ineffective assistance of counsel?
No, how many armed felons are out there that committed their armed felonies when they were between 17 and 19?
Well, we would agree and suggest that the court take the same position that it did in Rudolph, that it be retroactive to cases that are on appeal, but not anything other than that.
Okay, counsel, thanks. Counsel?
Good afternoon. May it please the Court. David Harity for the people. For an ineligible youth like Mr. Middlebrooks, the youthful offender statute does not require a court to address the possible existence of mitigating circumstances. In Rudolph, this Court read the language of the statute to require a Y.O. determination.
Suppose there are mitigating circumstances.
Well, Your Honor, the defendant is free to raise those with the judge. The judge could find them on his or her own based on the record, the trial, or
The judge has no responsibility?
not when it comes to an ineligible youth, Your Honor. The judge can proceed to sentence the defendant as an adult without addressing the issue.
Doesn't it make sense, pursuant to Rudolph, that the judge might raise this issue?
Respectfully, Your Honor, I don't believe so.
Why not? Because why isn't it better, even if you assume that Rudolph doesn't mandate it, but let's assume your adversary wants us to extend it a little, why isn't that a better rule? When the whole purpose is, if these kids could get a YO, it would serve them well, it's better for the kid, it's better for society. Why isn't it a better rule to say the judge should raise it?
Respectfully, Your Honor, I think that Rudolph was a case strictly of statutory construction where this Court
You don't think there was a policy reason behind?
No, Your Honor. I think the language of Rudolph was that this Court found that the legislature's policy, that the use of the word must reflected the legislature's policy choice, that a YO.
Do you think that the statute as it exists shows a different legislative policy relating to this kind of situation?
I do, Your Honor. The reason why we have this different rule is because the state legislature amended the statute in 1978 to exclude armed felons like Mr. Middlebrooks and Ms. Lowe.
Except in certain circumstances, right?
Well, Your Honor, the legislature gave the court the option to override the presumption of ineligibility.
Well, why do you read it that way? I mean, the language is pretty straightforward. You have eligible youth means a youth who's eligible to be fined a YO. Every youth is so eligible unless you've got the unless. And then you've got notwithstanding those provisions. That youth who fits under these exceptions is an eligible youth if the court determines. How is that not an exception to the exception? Why is that not a carve-out reflecting, you can call it policy, whatever you want under Rudolph, but reflecting a legislative policy choice that there are a category, even of those who fit under 2, who would otherwise be ineligible, who are eligible if the court exercises its discretion in that way.
Your Honor.
Why is that? I guess I am finding it very difficult to understand in both these cases why 720.10 is not about how a judge figures out if someone is an eligible youth, and that includes figuring out if the youth fits the exception to the exception. Maybe you can help me understand.
Yes, Your Honor. 720.10 sub 2 is the category in which I believe the defendant, a judge determines whether a judge is eligible or presumptively ineligible. That's where eligible youth is defined. And as Mr. Middlebrooks.
But 3 is pretty clear. 3 is very clear. Notwithstanding 2. Right?
Yes.
A youth is an eligible youth.
I think another way of reading 720.10 sub 3 is if the defendant is an eligible youth if, but only if, unless and until a court determines that mitigating.
Absolutely fair, but it still means you're an eligible youth.
Under those circumstances, Your Honor. But I believe that the best reading of 720.10 is that a defendant is ineligible, he is presumptively ineligible, and there is no mandate that the court rule on the possible existence of mitigating circumstances.
I'm wondering what – I'm sorry.
I'm sorry. Then why – I'm kind of with Judge Rivera on this one. Why is it in the statute if the court doesn't have to rule on it?
Because, Your Honor, I think it's a case where if a defendant is ineligible, but a judge wishes to make the defendant eligible because of these extraordinary circumstances, the statute allows for that override.
Another way to read it would be to say that while it says must in this circumstances, the fact that it doesn't say must doesn't mean that this court couldn't read into it a requirement that you do so. See, the thing is sometimes I think we're precluded from doing something here, but here I don't think we're necessarily precluded. And I think for your argument to be successful, you got to argue that we're precluded almost from saying to the judge, you got to consider this. And I don't read the statute that way. That seems to be a logical reading of it. We could read the must into there because there's nothing there. See my point?
Yeah, I do, Judge Fahey. What I would argue is that where the President, where there's mandatory language throughout the statute, the absence of mandatory language means that there's an absence of a requirement.
Taking it one step further, Mr. Hardy, is a rule, and court asks this question a lot of people when they come up here, but as a rule, wouldn't it make more sense to just every time somebody comes up, if they're in a certain age category, you got to make a determination of whether or not they're YO, and the court's got to make that determination all the time in every instance. Now, the factors may differ. If you're an armed felon, then the factors are there's no mitigating circumstances and there wasn't minimal involvement. Those are the only factors I can consider by statute. So the factors may differ from case to case, but you're going to need a PSR, and you're going to need to look at their history to see what it is, see if there's any mitigating circumstances. But so that may differ from a straight YO, where there's not an armed felon or a sex offense crime. But it doesn't prevent the court from saying there needs to be a determination here as to that one way or the other. You see what I'm saying?
I do, Your Honor. But I think it's not necessarily a bad practice to, when a youth is before the court, to make, go through all the steps, see if there are mitigating circumstances, relatively minor participation.
So shouldn't we as a policy say, listen, in all these cases, you may have different factors, but you got as a policy.
I respect
make this determination, Judge.
I respectfully disagree that it is required, Your Honor. I think that if the legislature
it's not required.
I assume it's not required. Do you think we're precluded from saying that it can be required?
Well, I would say that
Judge Harity.
Yes, Your Honor. I respectfully, I think the best reading of the statute is to rule that it's not required.
But isn't it more consistent again with the policy behind Rudolph?
No, Your Honor.
That the court should consider it. This is a kid, and the court should consider it.
I would say, Your Honor, that there is not necessarily any policy behind Rudolph. It's statutory construction, and
But again, it's the policy behind the whole statute.
Yes, Your Honor.
And the point is, I think as Judge Fahey was trying to make, it doesn't say we can't. You can't consider it. Why is it more consistent and logical and the best interest of the young person and of the system for the judge to consider it? What's the great harm if the judge considers it?
I'm not sure there's any harm, Your Honor. I just think I think that the analysis of the case is to read the statute.
If there's no harm and the statute doesn't preclude it, and it's better for the young person, why isn't that the way we should rule?
Well, let me suggest that there are some victims here, and let's just take a triple homicide, and let's say, you got an 18-year-old, and somehow we're reading the statute say it's not that you can find these, you must. The fact that he murdered his family, you still got to say, I'm going to take a look at this and see if there are mitigating circumstances that maybe we can give you a YO, so nobody will know you're a murderer. It'll be covered up in your YO status, and it just seems to me that somebody's got to make that move before the courts do. I mean, we're not adjuncts to the defense. I mean, we're supposed to be the detached and disinterested magistrate. I don't know why. Depending on how we decide this, why the DA wouldn't be in these cases. And by the way, Judge, there are no mitigating circumstances. We'd ask you to deny YO, and then the defense can do whatever it wants. But it shouldn't always necessarily be on the defense, I would think.
I think, Your Honor, that, and I agree. I think that this reflects, if I could just finish.
Yes,
Your Honor.
finish your thought.
That this does reflect the legislature's policy to exclude armed felons like Mr. Middlebrooks from youthful offender eligibility. And I don't, based on the statute, it's not necessarily on anyone, whether it be the judge, the DA, the defense counsel. It's just a case of that the judge has the option to override, but not the obligation to.
May I?
Judge Rivera.
I just want to clarify. Counsel, the section is a definitional section. So I'm a little bit confused about this argument that you need mandatory language. Provision 1 defines youth. Provision 2 talks about a presumption and defines eligible youth. Provision 3, or paragraph 3, says, notwithstanding 2, an eligible youth is this category. It's a definitional section. There's no mandatory language that's necessary. It's telling you what steps to go through each of the paragraphs. I'm not certain why you're arguing that it's either must or must not. It's very clear. Each one is a definitional paragraph.
It is, Judge Rivera, and I think that my point is not just that it doesn't say must here in 72010, but anywhere in the youthful offender statute. And if the
72020 talks about what the court must do.
Correct.
Right?
Correct. Yes, that's right.
Based on those definitions.
Yes, Your Honor. The mandatory language can come in anywhere, and usually it is in
I'm sorry,
720.
then I misunderstood. I thought there was an argument being made that paragraph 3 required the word must.
Not necessarily subparagraph 3, Your Honor, but anywhere in the statute, somewhere in the statute. If there is an obligation on the court, that must be reflected in a mandatory language somewhere in the statute, especially where we have mandatory language.
Okay, Kathy.
Thank you, Your
Let's
Honor.
hear from your adversary. You have 1 minute. Go for it.
Just to follow up on what the Chief Judge and Judge Fahey were saying about policy considerations, if the court and defense counsel are both silent about mitigating circumstances and the court makes no determination pursuant to subdivision 3, we'll have a situation where perhaps a deserving young armed felony offender will be denied the fresh start that this court has deemed so important in Rudolph. And in our case, we would ask that the appellate division order be reversed, that the finding of the appellate division that there are no mitigating circumstances be vacated, the case remitted to the sentencing court for a consideration of mitigating circumstances by the court based upon evidence adduced by defense counsel.
Okay, Kathy. Thanks. Thank you all. Appreciate it.